Yeah, well, Lord Keane Simon has been putting the government's case, and in particular talking about in the past when Parliament has been suspended or prorogued for what he said were nakedly political reasons, going back into history, 1948, 1930, just to underline the case that actually Boris Johnson hasn't acted unlawfully. That is the charge against him, that the 11 judges at the Supreme Court are going to have to consider whether the Prime Minister did act unlawfully when he prorogued Parliament. Let's talk to a couple of experts who've been watching and listening to the proceedings here. Mikolaj Barczentewicz, who is a lecturer in public law at the University of Surrey and also from the centre-right think tank, the Policy Exchange, and Joel Grogan, who's a senior lecturer in law at Middlesex University of London. First of all, Mikolaj, listening to Lord Keane for the government, how would you summarise his case?
I think Lord Keane so far made two very important points. First, that there is no difference in law as applied by the English court and by the court in Edinburgh. So they're just disagreeing on an application of the same legal standards. So that's the first point. And the second point, which I think is the key of the government's case, and this is correct, the problem is non-justiciable. So it is not for the courts to decide on what's a proper purpose for the Prime Minister to advise the Queen on whether to prorogue a Parliament or not.
So is that essentially what the government's case is, that this is a matter of politics, not for the law, not for the courts to decide?
Precisely. So there is this distinction between what is constitutionally required and what is legally required. And even if it was unconstitutional for the Prime Minister to seek that prorogation, it does not follow automatically that it was unlawful, and I don't think it was unlawful.
Because Lord Pannick earlier on for Gina Miller arguing the opposite, saying that effectively, well, his words were that Boris Johnson, the Prime Minister, was trying to silence Parliament because Parliament he saw as a threat and an obstacle.
Exactly. This is why we saw the three central points or arguments or questions of Lord Pannick this morning. First, and this goes to the point just mentioned, justiciable. Is this a matter of law? Now, I would say that if something is unconstitutional, that would also automatically mean it's unlawful. But it is this question. If something is a legal power, then it's subject to legal restraints. This comes back to the foundation of our legal system, the rule of law. If you have a power, it is fettered. That's the point of our Constitution. But the second issue is going to be whether or not there are established legal standards against which we can judge this power. Now, what Lord Pannick was doing was looking back at all the different precedents that we have of times in which we've looked at prerogative powers and the courts have looked at prerogative powers and said, well, you can't use them in that way. You can't use them to frustrate a statute. But the difficulty, and this is why it's such an unprecedented case, is we've never seen this situation where there's not really a piece of legislation. But the most difficult, this is the most difficult argument for Lord Pannick, is to, well, infer from silence. Prorogation is completely ordinary power, but the argument must be it's an ordinary power used for ordinary purposes. If this was used for an unlawful purpose, it's not lawful, it's not constitutional.
And Mikolaj, what did you think of what Lord Pannick was saying earlier on behalf of Gina Miller? This was Boris Johnson trying to silence Parliament because Parliament's in the way, an obstacle, a threat.
I think that was a very useful strategy for him to employ, to focus on those allegedly improper purposes, perhaps even unconstitutional purposes that Boris Johnson may have had. But I still think that this is not legally relevant. So this distracts us from the real issue, which is, does the law control exercises of prerogative to prorogue? And I agree with the government that it doesn't. So this whole discussion about what were Boris Johnson's motives is not legally relevant.
And do you think that's what the 11 Supreme Court judges are going to agree with? That's the view that they will take?
I think they will. I think this is the orthodox view, as Lord Sumption said last night on TV, and I think this is still likely to be the view of the court.
Joel, do you go along with that? Do you think that's what the 11 judges will decide?
I look forward to seeing their judgment. But the big difficulty, if they decide that it is unlawful, is, well, what's next? Are we going to hear, as Boris Johnson said yesterday, that the respect for judges, the respect for the independence of the judges, and respect if the judges say that it is unlawful?
And Mikolaj, finally, going back into history, as we've been hearing from Lord Keane, is that useful, going back to 1930 and 1948, talking about how Parliament was prorogued back in those days?
No, I think it is useful because this is how the law works. So if we have instances of unquestioned lawful exercises of prerogative powers, this is very good evidence for us that of the scope of that power, right? The law doesn't change. The rules, legal rules, don't disappear just because they are not used for 40 years, contrary to what Lord Pannick may have been suggesting.
All right, well, we will see what the judges think. These hearings are going on for 3 days, and then we may not get a judgment until next week, in fact, so we might have to be patient. But let's, in the meantime, listen in again to Lord Keane arguing the government's case. Lord Keane, the government's chief law officer in Scotland, who's been presenting the government side of this fascinating argument with huge legal, constitutional and political implications.
And indeed, if we